today's topic is actually a very interesting one, right? It's quite unique because there's really no statute or case that's going to make any of us use or embrace principles of diversity, equity, and inclusion. So today's presentation doesn't contain a lot of case law or any of that because it's about me creating awareness for this topic, right? DEI is probably a very sensitive and difficult topic for many of us to discuss and many of us to kind of embrace, right? Because it's kind of incumbent on each person to believe and to understand the concepts introduced by DEI, right? But today's topic I thought was very important because it actually stemmed from Newsday's expose of real estate agents on Long Island back in 2019. And the reason it concerns me is I've been a resident for 40 years it is personal. I've been a resident of Long Island for over 40 years. And as a minority, I did experience discrimination in my town. So maybe it's just my rose-colored glasses that I put on, but I thought we've come so much farther than we have. The expose, to say the least, was very disheartening. And diversity and inclusion has seen a resurgence since at least 2020, and making awareness much more important for all of us, not just us attorneys, but obviously everybody in the real estate industry. So to understand where we are today, I think it's important to go back in time. So I'll be doing a little bit of history here in terms of discrimination in real estate generally, right? Because I think it's important to see where we were versus how far we've come in order to fully understand where we are, right? So before I get started, I want to start with definitions because I think it's important that we're all on the same page about what we're going to discuss today. So the Georgetown University's National Center for Cultural Competence was a great resource in me finding definitions for us today. What is discrimination? I'm going to give you the definition provided by Georgetown's website, which is the unjust or prejudicial treatment of different categories of people or things, especially on the grounds of race, age, sex, or disability. What is prejudice? Being prejudiced means you have an unreasonable dislike and distrust of people who are different from you in some way, especially because of their race, sex, religion, or some disability. Racism is the belief that different races possess distinct characteristics, abilities, or qualities, especially so as to distinguish them as inferior or superior to one another. Bias is a manifestation of these three behaviors. So being prejudiced is a bias of attitudes, right, or beliefs that each of us have about a person or a group of persons on a conscious level. So for example, a real estate agent thinks a buyer can't afford a piece of property because of their ethnic background, but as it turns out, the buyer has a strong financial profile. But it's an immediate reaction to what you see, right? So that's being prejudiced because you already have these predetermined ideas. Discrimination is a bias manifested by overt and negative behavior expressed through physical and verbal harassment or subtly by exclusion. So, for example, a landlord refuses to rent to an applicant because of their ethnicity, even though the applicant meets all the rental requirements. This is how bias is being bias is being manifested in each of these categories. Racism is a form of bias that includes both bias attitudes and behaviors specifically related to race, often institutionalized in societal structures and systems. So, for example, a bank consistently denies loans of applicants from predominantly minority neighborhoods. So, what is the importance of knowing the definitions of these terms? Because these terms are very much related to our topic today, because they all three are present in some way in today's real estate industry. So I'm going to start by talking a little bit about a history of discrimination in the United States, because again, it's important for us to know where we've been. So prior to the 1930s, home ownership was near impossible for everyone, because the lenders actually required a greater down payment. A third of the home's value was required in order for you to even look at or consider having or buying a home. Also, there were shorter payment terms. 5 to 7 years was the term for payment. So those stringent requirements delayed home purchase until many purchasers were much older because of the savings required. Blacks particularly struggled, even though they were emancipated in 1863, they still were not where the majority was, and discrimination was pervasive before the 1930s, right? So one of Kennedy's New Deal reforms was the National Housing Act of 1934, and it asked the FHA, the Federal Housing Authority, to stimulate home ownership. And what was the policy for doing that? Well, the FHA started insuring loans made by lenders who provided low down payments and mortgages, and longer term loans. So by fixing the problem at the time prior to 1930 of down payments and terms, we're now going to insure so that you can lower your terms and have lower down payment requirements. So in the event of default, the FHA as insurer would take over payments. And so that there's less risk of default for the purchasers, for the borrowers. For the lenders, I'm sorry. This initiative resulted in an increase of home ownership, especially among the younger people. But the requirements of the FHA proved to be discriminatory, unfortunately. So every neighborhood in the FHA rule book, for lack of a better word, was rated either A, B, C, or D. D was considered the lowest quality risk, whereas A was the greatest quality risk. These ratings were based on age and types of houses, whether neighborhoods were homogeneous, meaning the presence of American businesses and professional men and American whites. Those neighborhoods earned the highest rating of A. Predominantly Black neighborhoods were a D. So conventional loans were still an option, but again, these were not insured conventional loans. So they were higher in interest rate, higher in low down payment requirements. So was it really an option? This type of practice has been known as as redlining. And if you look at this map of Brooklyn back in the 1930s, the red zones are considered Ds. And the lender would not lend to these neighborhoods. So I asked myself, how did the FHA get away with this kind of practice? The FHA justified it by saying C and D areas were more likely to default and would be bad for the economy. So how could we lend to them? And that was enough to continue this practice. The catalyst for turning this around or getting rid of redlining was a Supreme Court decision called CLE versus Kramer, where the Supreme Court held that courts could not enforce racial covenants. And the story behind this case was that a suit was brought by a husband and wife to enforce a restrictive covenant, which prohibited the occupancy of any person, and I'm quoting this, okay, any person not of the Caucasian race, specifically people of the Negro or Mongolian race, for a period of 50 years. So the defendants prevailed here in the lower court and of Missouri, but the appellate court reversed. The Supreme Court got involved because this was a question of whether or not the covenant, even though it's private, violated equal protection of the law, which is Amendment 14. So the Supreme Court said state courts may not enforce these restrictive covenants, even though they're private agreements, because the courts acting is tantamount to states acting. And as a result, that would deny persons equal protection under the 14th Amendment. As a further initiative after this case, the Fair Housing Act of 1968 was passed. The hope with this passage was to desegregate the areas that you see right now as red or C and D zones. So the Fair Housing Act provided that we ban discrimination on sales or rentals of all housing. It authorized the Secretary of Housing and Urban Development to investigate allegations of discrimination. It allowed the HUD to issue complaints against those suspected of discriminating. It allowed HUD to hold hearings to assess the severity of the discrimination and publish cease and desist orders in cases where discrimination was confirmed. It also empowered the Attorney General to prosecute agents who engage in a pattern and practice of discrimination and individual victims of discrimination. Also authorized the Attorney General to prosecute these actions on behalf of aggrieved parties, because the aggrieved parties were authorized to file civil suits in federal court for significant damages and punitive awards, court costs, and attorney fees. So this all looked great on paper, and it looked like this was going to be very impactful. However, HUD only had 30 days to decide whether to pursue or dismiss allegations after investigation of complaints. They also can only engage in conferences or conciliatory in acts of conciliation and persuasion to resolve the complaint. It didn't allow HUD to transfer the case directly to the US Attorney General to prosecute these cases against the perpetrators. So they had really no way to enforce any of the compliance requirements or grant a remedy. They didn't have any way to assess damages or prohibit the discriminatory practices. They were basically an agency that allowed for an avenue where participant or victims can complain about their discrimination. Okay, so it allows them to complain. The Attorney General, the U.S. Attorney may or may not agree to file suit on behalf of these on behalf of those victims. So basically, you have all these rules of no discrimination, which was great, but you had no avenue within which to actually do anything about it. So before we get to our next slide, our next topic, true or false, discrimination is a form of bias manifested by overt negative behavior through physical and or verbal harassment, while being prejudiced is a bias manifested as attitudes or beliefs that each of us have about a person. Is that true or false? I'll give you a second. That is true. Recall that this is how bias is manifested as overt actions or attitudes and or beliefs. So let's see how it at all, given that the Fair Housing Act of 1968 really had no bite, did it impact? How much impact did it actually have? So the HUD actually conducted a study in 2012 on housing discrimination and in the US. They use what's called the paired testing method. What is that? It's two trained individuals, one white and one Black or Hispanic or Asian, where each were equal in all aspects of purchasing or renting a home in terms of qualifications. The only difference between the races was their color, okay, and or their ethnicity, excuse me. So what was the finding? People of color were still facing discrimination while searching for homes. So 8,047 paired tests across 28 metropolitan areas, including Atlanta, Chicago, Dallas, Detroit, Philadelphia, Riverside, DC, San Diego, Houston, LA, Miami, big cities, where the tester would contact a housing provider to inquire about housing units, randomly selected from advertised homes and apartments in the newspaper. Each pair matched in age, gender, again, very, very exact match between the two ethnicities. And what was found was the following. 11% of the time, Blacks were told about listings, right? 4.2% of the time, they were advised or shown the listing. But if you look at these graphs, you're looking at much, what is it, 80% of the time, they're not doing, or the agents are not doing what they're supposed to do, right? They're still discriminating against Blacks, Hispanics, and Asians based on these graphs. Additional findings included the fact that home seekers whose ethnicity is more readily identifiable experience more discrimination. For example, Blacks and Asians who are looking for apartments or homes whose race, obviously they're much more identifiable in name and speech and appearance, would be refused to be shown apartments or told about listings. More blatant forms of discrimination have declined since the passage of the Fair Housing Act, but discrimination still exists. Agents are more open to setting appointments regardless of race, or blatant denial of showing certain units or homes are less likely, but as you can see, it's more subtle. It's more subtle now. This study does not include any of the same-sex couples or sexual discrimination based on sexual orientation. And in 2013, HUD did publish the results of a study involving 6,900 paired tests across 50 randomly selected housing markets, where half of the tests compared treatment of gay couples with that of heterosexual couples, and found that 15% of the time heterosexuals were favored over same-sex couples. This study understates the level of discrimination because same-sex couples, they only tested the first step of the rental transaction. They didn't test any other, that is the inquiry. That's it. They didn't test whether or not it was going to be shown, whether or not it was going to be told about. It's just whether or not they, when they were inquired of any openings, they were denied 15% of the time, only 15% of the time. So just a point of comparison, and I love numbers. So, because numbers tend not to lie, right? HUD conducted a similar study back in 2000. So this is the results of the 2000 versus 2012 study. And if you look at, rental discrimination, you can see that there was a change where much of the comparisons have decreased. You have where we have advertised, where there's an advertised unit available. Were they advised of that? Yes. Most of the time, it's decreased to 0.2, 0.27%. In terms of being discriminated against, meaning that they're more likely to be told of an opening or be shown or offered incentives, or future arrangements were made with real estate agents and the agents actually showed up. So the changes, while de minimis, are for the better, and small changes are better than no changes, right? Blacks are less likely to be told that an advertised unit was unavailable. Asians less likely to be shown fewer units because of their ethnicity. Minorities less likely to experience adverse treatment when making future agreements with agents. And sales, again, very small changes, but better than no change. So, another true or false question. The Federal Housing Authority positively impacted discriminatory rental and sales practices because its policies decreased the number of incidences of not showing advertised rental units to minorities and adverse treatment of minorities when making future arrangements with real estate agents. Is that true or false of the Federal Housing Authority? That is false. Remember that the Federal Housing Authority engaged in the pattern and practice of redlining, which segregated communities. The Fair Housing Act of 1968 was the applicable act that has been creating some positive momentum. So, how far have we really come? Now that I've given you some history, how much closer are we to eradicating discrimination in the real estate industry? And as many of you have probably read, back in 2019, Newsday conducted a 3-year investigation of the housing discrimination on Long Island. This is 19 years after, the studies conducted by HUD. And just to refresh your recollection of what happened, they employed the paired testing method, Newsday, and obviously it's not just the reporters, they actually had experts on hand to conduct these paired testing, similar financial profiles, requesting identical terms for houses in the same areas. 39 tests paired Blacks and whites, 31 tests paired Hispanics and whites, and 16 paired Asians and whites. There were 5,800 listings at the time of this test, from New York City to the Hamptons, and they tested 12 of the top performing real estate brokers and 93 of their agents. And unfortunately, Newsday confirmed that the agents were discriminating against Blacks, Latinos, and Asians. They found disparate treatment between whites and minority testers. 40% of the time, agents subjected the testers to unequal treatment, with Blacks experiencing the highest, 49% of the time, followed by Hispanics, 39% of the time, and Asians, 19% of the time. These are some pretty decent numbers in terms of discriminatory practices. In 7 of the tests, 8% of the agents accommodated white testers while imposing more stringent conditions on minorities. Commonly, agents refused to provide home listings or home tours to minorities unless they were pre-qualified. These are all examples of steering, right? The unlawful practice of sorting home buyers based on race. This is overt discrimination. Action is being taken, not just attitudes of racism. These are overt. You're talking about backgrounds of people who live in neighborhoods is steering. Just a few quotes that I read, which were shocking to me, was one agent advised a Black customer, every time I get a new listing in Brentwood amidst the MS-13 gang murders, and is Brentwood is 79% Hispanic and Black. I get so excited, she says, because they're the nicest people. While advising a white tester, please kindly do some research on the gang-related events in that area for your safety. Another agent actually said, I'm not going to send you anything in Wyandanch unless you don't want to start your car to buy your crack. I mean, shocking, right? Very disheartening for me. And it's not every agent. 89 agents were tested. It's not every single one of them. These are just some of the ones that I found shocking, right? So, unfortunately, Long Island remains highly segregated, is what Newsday found. So before I move forward, here is the verification code. For today is fair for those of you on the phone. And once I leave here, I cannot repeat it, nor can Diana, nor can anyone else at Judicial. So please write it down so that you can provide it to Diana after this program, because again, it will not be repeated once I'm off this slide. Okay. In 5, 4, 3, 2, 1. True or false? The goal of the Fair Housing Act of 1968 was to end housing discrimination and reverse housing segregation by prohibiting discrimination in the sale, rental, and financing based on race, religion, sex, and disability. And while it has had a positive impact on housing discrimination, its goal has still not been fully realized. Is that true or false? That's true. Remember that one of the challenges for the Fair Housing Act is that HUD doesn't have enforcement capabilities, right? It can investigate and resolve for the victim, and it chooses the matters to be tried, but the burden of enforcement of discrimination is on the victims who are required to file a formal complaint with HUD to sue in federal court, filed by the U.S. attorney. And by the way, the U.S. attorney, despite the fact that you may complain to HUD, the U.S. attorney is still the person who decides whether or not to enforce a particular case. So now you have an aggrieved party with really nowhere to run after being told, hey, your case isn't a pattern or practice, or it doesn't raise an issue of general public importance. What does that mean, right? General public importance. Isn't it important that someone is being discriminated against? Why? What is meant by general public importance? And we'll get to a case actually that is as new, and that's been interpreted. So do we have hope for the future? What does the future look like for us now that we have all the information within our grasp, right? And we've been made. Housing discrimination has been in the U.S. since late 1930s, and it seems that we've only made very, very de minimis strides in eradicating it. And despite the fact that the federal government has provided avenues for eradication of discrimination in the housing arena, it seems that it's still not enough. So I can give you some hope here. The investigation did bring about some positive events, one of which is the prosecution by the U.S. Attorney of U.S. versus the Village Realty of Staten Island versus Dennis Donovan. This is a brand new case, just decided in 2020. And Donovan was an agent with Village Realty of Staten Island, and he was primarily showing rentals to interested renters. And the U.S. tested Village with paired testing between February to May of 2018 And Donovan was caught, for lack of better terms, was caught telling Black testers about fewer rental units than white testers. He also offered white testers rental discounts and opportunities to inspect units, which he didn't offer to Black testers. And he only offered Black testers unit in racially mixed communities while offering white testers in both overwhelmingly white communities and more integrated neighborhoods, basically steering. He made himself more available to show units to white testers, and Donovan was more willing to waive certain requirements for whites. For instance, credit checks, sign disclosure forms, or inspect units, but not for equal treatment with the Black testers. So unfortunately, they prosecuted, which is great, right? But they settled. So anytime you bring an action, you want it, especially when it concerns something so important, you want it to be a precedent. So while this was a step in the right direction by prosecuting and making these findings, unfortunately, the settlement was not, I can tell you about it. I can tell you about the settlement, but unfortunately, it's not going to act to deter, right? It could act to deter, but again, with a settlement, you're not going to have that precedential case law that you need in order to put up a piece of paper and say, stop doing it, or this will happen to you. So they settled it, and Donovan and Village Realty didn't admit to any truth of the US allegations. Village promised they're no longer engaged in offering listings for rentals. Donovan will no longer offer units for rent. Village and Donovan are enjoined from refusing to sell or rent a dwelling, failing to provide information about a dwelling, refusing to negotiate. They were requested to establish a $15,000 settlement fund for the purpose of compensating aggrieved persons who may have suffered as a result of their discriminatory practices, and they had to pay the United States civil penalty of $2,500, slap on the wrist, for findings of discriminatory practice, right? So there's this bit of disappointment there, unfortunately, for eradicating discrimination. Lawmakers call for this, another positive step. Lawmakers call for the reform of the New York State real estate industry after the investigation. They conducted a year-long study by a coalition of 3 New York State committees. The study included subpoena documents of real estate companies and public testimony of dozens of witnesses and fair housing experts. The Senate report concluded currently insufficient enforcement of fair housing laws and confirmed use of steering. They confirmed the unfair treatment of Black and Hispanic buyers. Most agents who testified believe they did nothing wrong, despite being caught on camera, actually practicing discrimination. Dozens of agents refused to testify. Some principals of the real estate agencies represent they take fair housing very seriously, and if any statements offended anyone, that was not their intent. So there's this kind of maybe, rose-colored glasses on their part in terms of the conduct. because I don't think anybody intends to be discriminatory. I don't think anybody intends to be prejudiced. It just happens. Right? So sometimes, I think many people who are completely believe that they are not discriminated or prejudiced end up saying or saying things or acting in a way that is discriminatory because of things they don't even know about. We know about explicit biases, but we don't even know about the implicit biases that we have that have been ingrained in us for years and years and years and years. Right? So I get why these principals and real estate agents thought they did nothing wrong, because it wasn't intended to do, and they didn't intend to do anything wrong. So the legislators, after this study, recommended that an increase in fair housing, CEs, continuing education, doubling the fines if discrimination has been found, open offices in communities of color. So these are all legislator recommendations as a result of the study. In addition, agents who did discriminate face discipline. As of April 9th, 2021, the state actually revoked the license of one of the agents that was involved in the Newsday investigation, and I'm sure there are about 18 others that probably suffered the same demise, but I haven't looked into that recently, but I think they probably suffered the same demise where 18 of them were removed as got their license taken away. The state filed complaints against real estate instructors for failing to comply with New York law by making inappropriate or offensive statements in class. The state opened 52 additional investigations into potential misconduct by real estate professionals tied to the investigation. So, look, things are being done. Things are being done, which is great. And awareness, again, I bring this to your attention again. Awareness is key here. I know that before I started doing the research for this particular class, I didn't understand the gravity, right? So I'm bringing it to you so that you understand the gravity. And I hope that I've given that to all of you. New laws, right, are now effective as of April 20th, 2022. Real property law section 442-H and 441-C requires real estate brokers to have standard operating procedures designed to prevent real estate agents from setting different standards for home buyers, meaning they need to create policies about whether to require prospective clients to show IDs, to sign exclusive broker agreements, to receive pre-approval before working with a client, so that there are standard operating procedures for every single agent within that brokerage. And everybody has to follow the same rules. That way it cuts back on any biases by an agent. Another policy, another part of the law, real estate agents must be supervised by associate real estate brokers that serve as managers. So that, they're better trained in terms of discrimination. The state may file complaint against a manager for failure to supervise if an agent engaged in discriminatory practices. Brokers must publish their operating procedures on their website or mobile app or posted in their offices. And bias and diversity continuing education is required for all real estate agents, at least 2.5 hours of culture, 2 hours of, 2 hours of continuing education regarding bias and diversity, and 2.5 hours of cultural competency. Other challenges to the diversity issue is the fact that there's a lack of diversity in, there's a lack of diversity in real estate in general. Many of your real estate agents are Caucasian or male. Actually, I correct that. Real estate agents for residentials are primarily female, but for big commercial deals, commercial real estate firms, it's predominantly male. So we have a lack of race diversity in real estate, right? Attorneys, lack of diversity as attorneys in the real estate industry as well. And of course, I mentioned implicit biases, which we really don't even know about unless we take implicit bias courses. We're not even gonna understand that unless, because that's a whole course that I teach in of itself. So what is the hope for the future? The hope for the future is awareness. The hope for the future is you take the information you have and you become more aware of what is happening around you, especially in the real estate industry. Diversity comes from us as individuals. So I'm not going to go on a long soapbox mission here, but I thank you for your attention and hope that I've given something back to you that you can react with or do something good with. So thank you for your patience and your time. Any questions, Diana?
I don't have any in the Q&A box right now, but if anyone has a question that they did not want to put on the chat, I know sometimes it's a sensitive topic, so you might not want to put it out there. So if you have any questions, you can shoot me an email and I will get the answer to you. But thank you again, Toni, for another great CLE. It's greatly appreciated. After the lecture this afternoon, I will resend everyone the affirmation material and evaluation just in case you did not receive it, and you should expect to receive your certificates within the next week. Any questions, please just send me an email, and I'm getting a lot of in the chats. Thank you. It was a great CLE. So thank you again, Toni. We always love having you.
Thank you for having me. I appreciate you.
Have a good one.
You too. Have a great one.